Hello, and welcome to the ABA section of the Environment, Energy, and Resources podcast. My name is Matt Wickersham, Year in Review Vice Chair for the Environmental Litigation and Toxic Tort Subcommittee. This podcast is part of our series concerning the major environmental cases that were decided in 2018. This section of Environment, Energy, and Resources publishes a Year in Review publication discussing the major environmental issues that have happened over the past year. And we have with us today one of the co-authors of the Environmental Litigation and Toxic Torts chapter to discuss his contribution to the Year in Review publication. Our guest today is John Watson, an attorney with Spencer Fane in Denver, Colorado. John has been a defense trial lawyer for 44 years, practicing in the environmental and natural resources fields, representing companies and individuals in toxic tort cases, CERCLA, and air, water, and waste regulatory matters. John, thank you for joining us today. So, what case was the subject of your contribution to this Year in Review publication?
This case is a case that was decided in October of last year by the Third Circuit Court of Appeals, and it's styled Giovanni versus U.S. Department of the Navy.
And what was the issue addressed in the Giovanni case?
The issue was whether or not state law-based claims for medical monitoring and health-based assessments were improper challenges to Superfund cleanup actions. The case involved contamination that emanated from a naval air base in Warminster Township in Pennsylvania. The contamination consisted of PFAS. Those are chemicals known as poly and perfluoroalkyl substances. They're used by the Navy and other defense bases, for example, in fire suppression activities. The case here was filed by local citizens, a husband and a wife and their children, whose private well had been contaminated by PFAS. And they had filed claims in state court requesting a medical monitoring fund, a state law-based claim for medical monitoring. And the issue was whether or not that claim and a request that they made for a health effects study was an improper challenge to the CERCLA cleanup. Of note here, before we get into any substance of the decisions by the District Court and the Third Circuit, I've noticed that the Navy had actually admitted to the release of the PFAS, and there were no other potentially responsible parties, no other PRPs involved in the matter.
So what type of claims were brought against the Navy, and how did they respond to them?
Well, the Superfund cleanup was ongoing, and the plaintiffs filed an action in state court seeking the establishment of a medical monitoring trust fund, and also an order from the court to force the government to undertake a health effects study. The Navy, not surprisingly, removed the action to federal court, and the Navy filed a motion to dismiss the plaintiff's claims.
And how did the district court handle this motion?
The trial court dismissed both of the plaintiff's claims under the doctrine of derivative jurisdiction. The trial court concluded that Superfund Section 113H deprived the court of jurisdiction to hear any claims that would interfere with an ongoing CERCLA cleanup, and that the medical monitoring and health study claims both amounted to an improper challenge to the ongoing response action at the site.
Interesting. So how have medical monitoring and CERCLA claims been addressed by the other circuits and other courts previously?
Before the Giovanni case in October of last year, there were very few federal courts that had directly addressed the question whether a state law medical monitoring claim could challenge an ongoing CERCLA removal or remedial action under Section 113H of the Superfund law. Most of those handful of decisions, all of them over 20 years old, held that medical monitoring claims are not the sort of challenge, not the sort of improper challenge that can deprive federal courts of jurisdiction. The district court, the trial court in Giovanni, broke that pattern. In that sense, the trial court was an outlier, a significant outlier. Because the district court was overturned on appeal to the Third Circuit, however, there is now no split between the Third Circuit and other circuits, for example, the Ninth Circuit Court of Appeals.
You said they split with these prior cases. Did the district court or trial court talk specifically about why it rejected the prior cases?
Yes, it did. The trial court in Giovanni rejected 3 decisions from outside the Third Circuit, all of which had held that medical monitoring claims are not improper challenges within the meaning of Section 113H of the Superfund Law. There is the Durfee case, a Ninth Circuit Court of Appeals decision in 1995 that the district court criticized. District court also criticized the Slava versus Hughes Aircraft case as a district court decision in 1993 in Arizona. And the trial court in Giovanni also criticized the Stepp versus Monsanto Research Corporation case, which was a Southern District of Ohio district court decision also in 1993. And the district court in Giovanni criticized those cases for what it referred to as illogically concluding that medical monitoring was outside the scope of the defined, quote, removal or remedial actions, because it is not recoverable as a circular response cost. And that was one of the main focuses of the district court criticism of those other cases.
What happened in these prior cases?
Well, if we take them kind of one at a time, the Durfee case, Ninth Circuit case, used the same underlying rationale as the Giovanni case, and quote, if medical monitoring were a removal or remedial action, then medical monitoring claims would challenge removal or remedial actions and would be barred by Section 113H of the Superfund Law until completion of the cleanup activities. But the Ninth Circuit, instead of analyzing the statutory definitions of removal and remedial action, the Ninth Circuit in 1995 asked the question of whether medical monitoring is included within the meaning of response, defined response, for which costs are recoverable under Section 107 of the Superfund Law. The court asked if it were not a response cost, then the Ninth Circuit reasoned it must not be a removal or remedial action, and therefore was not an improper challenge. The Ninth Circuit opinion only briefly discussed whether medical monitoring challenges an ongoing cleanup, concluding that medical monitoring was not directly related to establishing the effects on and dangers to human health at the site, which was one of the goals of the cleanup. Shifting gears then to the district court decision in Slava in Arizona, 1993. That court followed the same response cost logic as the Ninth Circuit in Durfee. But in the Slava case, the trial court provided more analysis of the impact of medical monitoring, or the question of whether there is impact of medical monitoring on the Superfund cleanup. The court noted that the medical monitoring program funded by the responsible party would in fact not delay or interfere with the cleanup activities, and therefore it was not an improper challenge. The district court in Giovanni also took umbrage with the Stepp case, again a district court case in 1993 in the Southern District of Ohio. There, the district court relied primarily on its conclusion that in seeking medical monitoring, the plaintiffs were not asking the court to review the remediation plan. And although the weight of the case law arguably is to the contrary, the court in Stepp also added that Section 113H of the Superfund Law applies only to claims under federal law. In fact, other circuits have found that 113H encompasses any state law action that could qualify as a challenge to CERCLA. So there's a New Mexico case in 10th Circuit in 2006. There's a 1999 Ninth Circuit case that really goes contrary to the district court's discussion in the Stepp case.
So it seems like many of these courts are viewing the question as a definitional issue based on the statute, rather than whether a medical monitoring claim would actually interfere with the CERCLA cleanup.
Well, it's an important point, Matt, because the courts do vary in how they come at this. They may come to the same conclusion, but they go different directions. In each of the medical monitoring decisions, including Giovanni, a factual analysis of whether medical monitoring actually interferes with an ongoing cleanup seems to be a secondary concern to the extent that it is undertaken at all. The Durfee case in the Ninth Circuit, the Eslava case in Arizona, and Giovanni instead focus most of their attention on whether medical monitoring is by, as you say, statutory definition, a component of a CERCLA removal or remedial action, and the courts then reach their holding from that premise, again, as you suggest, focusing on definitions in the statute. According to the district court in Giovanni, the trial court, medical monitoring is included within the meaning of the definitions of removal or remedial action, and that's why the district court in Giovanni said that these were improper challenges. In the Durfee case, Ninth Circuit case, and its progeny, they say the exact opposite, that medical monitoring is not within the meaning of removal or remedial action. That's why the district court in Giovanni really was an aberration.
How did the Third Circuit resolve this issue?
Well, the Third Circuit got back in line with other circuits and other district courts. The Third Circuit Court of Appeals overturned the trial court's conclusion that CERCLA barred the state law-based claim for medical monitoring. Here, the appellate court partially agreed with the trial court that the resident's request for a government-led health effects study was barred as an improper challenge to the ongoing cleanup efforts being implemented pursuant to CERCLA. So in that sense, the Third Circuit agreed with the trial court. In contrast, the appellate court disagreed with the district court and concluded that the medical monitoring claims actually fall outside the CERCLA's definition of removal or remedial actions, and therefore the plaintiff's request for a medical monitoring trust fund was found not to be an improper challenge to an ongoing CERCLA response action.
So, government-led health study seems pretty similar to a medical monitoring claim, especially when it's brought against a federal agency. How did the court distinguish between these two things?
Well, the Giovanni Court, let me take a quote out of the Third Circuit's case. They said, quote, private party medical monitoring falls outside of the definition of response action, but government-led monitoring does not. In that sense, the court distinguished between a request to fund a medical monitoring trust, on the one hand, and the plaintiff's request for a government-led health study, which the court concluded constitutes a demand that another agency of the government conduct the same type of health effects study for which the Agency for Toxic Substances Disease Registry is already authorized to conduct. The ATSDR, as we call it, is always brought in to do some type of health effects study when we're dealing with removal or remedial actions under Superfund. And the Third Circuit agreed with the district court and said, that ATSR is already doing that type of health effects study. So to come in now, plaintiffs, and ask for another agency, here the Department of the Navy, to do a health effects study, that's basically getting two bites at the apple, and that would be an improper challenge.
So this case involves an additional issue in that it was brought against the U.S. Navy, a federal agency. How did this aspect play into the court's ruling? Well,
the Third Circuit also evaluated whether the doctrine of sovereign immunity could potentially bar the resident's medical monitoring claim. They referred to Section 6001 of RCRA, the Resource Conservation Recovery Act, which expressly waives sovereign immunity for the United States and all of its agencies and authorities for actions that seek to enforce federal, state, or local environmental laws due to contamination caused by the federal government, so long as the action seeks equitable relief rather than money damages. And the courts make that very significant distinction between a request for equitable relief or for money damages. Here, the Third Circuit found that medical monitoring claims, which seek that the defendant fund a trust to cover medical monitoring programs, is relief that is primarily equitable in nature. The court stated that the Navy will have to expend money does not in itself make the desired relief a demand for money damages.
So, what do you think the impact of the Giovanni case will be on future cases considering these issues?
Well, to get a handle on that, and before I get into it, I really recommend that the listeners to this podcast read the dissent by the Third Circuit member of the panel, Judge Bevis. Giovanni adds to a series of cases that draw these same conclusions that the Third Circuit does, that medical monitoring claims are not barred as an improper challenge to Superfund cleanups. But Judge Bevis takes a little different approach. He expands this in the following way. He agreed in his dissent that the ultimate conclusion of his colleagues in the Third Circuit had argued that the government-led health study was not barred by CERCLA. And so he agreed with the ultimate conclusion, but he argued the one next step further. He said, I don't think a health effects study is barred. His reasoning was that, I'll take a quote. Quote, I agree with the majority that the government took its response actions at Navy facilities under Section 104 of the Superfund law. So I join in that portion of the majority opinion. I also join in another portion of the opinion because I agree with the limited holding that RCRA's sovereign immunity waiver does not bar claims that seek a medical monitoring trust fund. So in that sense, he concurred with the judgment ultimately of the Third Circuit. But he questions whether or not there's a single workable test that's now out there for practicing attorneys and PRPs to deal with, and in fact for the courts. He states, quote, but I would adopt the D.C. Circuit's definition of a forbidden challenge, limiting it to actions that would actually interfere with the cleanup. He says, quote, at root, I disagree that who does an action bears on whether that action meets CERCLA's definitions of removal and remedial. He continues, quote, in other words, I am unpersuaded by the Ninth Circuit's decision in Hanford. And the Third Circuit talked about the Hanford decision at some length. He continues, quote, while that opinion relies on legislative history and remedial purpose, I would stick to the statutory text. At the very least, we should adopt a single workable test to determine what are challenges barred by Section 113H of the Superfund law. And then he continues, quote, under the correct test, neither medical monitoring nor health assessments qualify as challenges to removal or remedial actions. And then he cites back to 113H of the Superfund law. He continues, quote, I agree with the majority that private medical monitoring is not a challenge, but my conclusion would not change if the plaintiff sought medical monitoring by the government. The same is true for health assessment. So he takes it one step further. And for the listeners, it's very clear, not only when you read the statute, but also in the case interpretations. If plaintiffs were to come in and challenge, for example, a standard for the cleanup for benzene in groundwater, 5 parts per billion, that would be a challenge. That would be an interfering with the removal or the remedial action, and that would be barred by the law. Or if someone were to come in and say, no, we don't have to, we don't have to pay for the cost of providing a drinking water source for this community just because their drinking water has been contaminated. We don't have to pay to bring in bottled water for them. Those types of challenges clearly would interfere with the remedial action and removal actions that the government had decided needed to be taken. So that's pretty black and white. This is a gray area, though, and I think to answer your question, Matt, it continues to be a gray area. We've got the Third Circuit, and we have other circuits saying that medical monitoring, state law-based claim medical monitoring claims are not, improper challenges, so they're not barred. So that's consistent. But we still have a split in the courts as to whether or not these health effects studies would be improperly barred. So there's still gray out there. There is no single workable test, as Judge Bibas would like us to have. We still have some gray in the law.
Well, thank you again, John, for joining us today and spending the time. We really appreciate your expertise and insight on this issue, and it's clear that we will likely be hearing more about these medical monitoring and CERCLA challenges in the future. Again, our program has been sponsored by the ABA section of Environment, Energy, and Resources. You can find out more about our section, including how to join, at our website, www.americanbar.org/environ. That's ENVIRON. Until next time, this has been Matt Wickersham. Thanks for listening.